गुड डे टू ऑल। मेरा नाम प्रदीप शुक्ला है। मैं कन्वेंशनली लॉयर हूँ। मुंबई में 48 ईयर से प्रैक्टिस करता हूँ और आज जो यूट्यूब पे मैं मेरा वीडियो अपलोड कर रहा हूँ दैट इज़ वेरी यूज़फुल फॉर एवरी बिजनेसमैन, ईच एंड एवरी, स्मॉल और बिग। जनरली ऐसा बिलीव रहता है कि कोर्ट से ज़्यादा अच्छा रहेगा कि अगर आर्बिट्रेशन में मैटर चले जाए, so that the dispute can be resolved easily. 90% of the business people do not know the effect of arbitration. Once a matter is referred to arbitration, the Civil Procedure Code and the Evidence Act will not be applicable. So there are so many problems which can be solved by rightful person by cross-examining the concerned witness and put their case and prove that it is not possible under the arbitration. Now arbitration के लिए भी क्या है कि एक ऐसी चीज़ है कि there should be clear cut agreement that both the parties have really agreed कि in case of disputes the matter should be referred to arbitration and that the right to continue with the matter exclusively will go to the arbitrator. Now there are procedures of appointment of arbitrator. There can be 2 arbitrators, then 3 also, whatever is there. But the party's right under the Civil Procedure Code and under the Evidence Act is much higher than what is referred to the arbitration. Now in the arbitration there has to be clarity. Apart from the wordings, it should be clear that both the parties agreed to submit to arbitration and agreed to the consequences and the judgment given by the arbitrator which will be binding on parties. Now this is something which many businessmen do not know and just thinking that arbitration will be better than civil cases. So I just wanted to make it clear that of course civil rights are there available, but once you agree to arbitration, the Civil Procedure Code and the evidence is ousted, and that may be proved very dangerous to the litigant. So it is always better to understand the consequences of referring it to the arbitration. The present case was really a special case for the reason that the wordings were, I'll just read that it was happened that there was a fruit dealers and you can take it as a good sold and delivered, but then the wordings were that there was a union which was to be referred. It is, I'll just spell out the name of the association, that is Kashmir Fruit Growers and Dealers and Association Fruit Mandi Sopare. Now under this bylaws, matter was referred to arbitration. The civil suit was filed. Under the application, the matter was transferred to the arbitration. Now these are the facts. Yet there should be not only clarity that both the parties agreed, but they should also be aware about the binding effect of referring to the arbitration. Now matter had gone to the High Court. Now the High Court, I'll just give the citation. It's a High Court of Jammu and Kashmir and Ladakh at Srinagar. Case number is 214 of 2024 and party's name is Ghulam Rasul Bhatt, petitioner versus Shafid Fruit and Company. This is decided on 6/5/2025 by Justice Sanjay Dhar. Now, anybody who wants to understand in detail can go through the citations, but my personal advice as an experienced advocate of 48 years that give it second thought before signing such agreement that what are your rights and what are your rights will be curtailed. Thank you. God bless you.